Hey everybody, welcome to the Crash September webinar series. This is the fourth in our series that we're running on Crash September, basically showing everybody the expertise of my CAT team who are bringing some really important information to small business who really need the help right now. And today's topic is manage your debt before it becomes a legal issue. So I would like to introduce my panel now. And the panel, first of all, is John Ross from Effective Recoveries. John is a debt collector. Welcome, John.
Welcome. Thank you, Marg.
And Steve Walters from VMC Legal. Welcome, Steve.
Good afternoon.
So what we're going to do is we're first going to start off with Steve. Steve, can you just give everyone here today just a framework around the legislation that is happening in Australia. Now, I'm not sure if you've got a federal context or a state context in relation to the debt deferment. Could you just give us a bit of an overview of what's happening out there?
Just briefly, there's a lot of naysayers out there, but I think the government reacted fairly well to the onset of the virus, and they reacted fairly quickly, and we've seen a lot of that in the papers and the news, particularly as it relates to supplementing people's wages, keeping people's businesses going and so on. But in the environment of collecting debt and managing debt, there has been not a lot of material out there, but both the state government and the federal government passed legislation. The Commonwealth passed the Coronavirus Economic Response Package Omnibus Act of 2020, and in Victoria we had the COVID-19 Omnibus Emergency Measures Act. Now, by reason of those pieces of legislation and the regulations made under them, there have been protections brought in to assist businesses and assist individuals in being able to manage debt through this time when income might be affected. We see it particularly in extensions of timeframes. So whereas previously there might have been 21 days to respond to something like a creditor's statutory demand, that's been extended to 6 months. There has been deferments also in the area of insolvency generally, bankruptcy, and in dealing with some of the rules that apply in commercial law under the corporations legislation, whereby organisations can be penalised and directors can be held accountable if an organisation trades whilst insolvent. There's been changes to all of that, and at the moment, all of that applies until the 24th of September of next month, 24th of September this year. So obviously we've heard that the JobKeeper aspect has been extended to March of next year, but we don't know what will happen to these rules. So to a degree, we're talking about what may happen, or I think it's quite likely to happen, because clearly in the 24th of September, if everything just shuts off and it's back to business as usual, there's going to be people and organisations, particularly in Victoria with our worsened situation, that are going to be left in the lurch, so to speak, and it's going to be very difficult for them to operate. So I suspect we do have changes coming from the Commonwealth Government about that, but we don't know them at this time.
Hey, John, being a debt collector, the current market is a bit of a basket case, isn't it? I mean, seriously, we're here down in Victoria, and I'm just wondering if you could just share from your experience and what's going on out there, and tell us what you're seeing and what could have been avoided.
Yeah, well, unfortunately, being in the state that no one wants at the moment in Victoria, a lot of the work we're getting, and the work is quite busy at the moment, but a lot of the debtors we're chasing, unfortunately, have closed. So for a lot of people, it's a case of sit back and wait and see what happens. Steve will go through some of the stuff that's happening. So the enforcement actions that we used to be able to take, we can't take at the moment. Stat demands on people, you know, it used to be 21 days, it's now 6 months. And we're finding with a lot of the banks, I don't know if there's any banks, Pete's just about to join us now, but we've found that a lot of the banks have also wound back their collection. We were doing a lot of repossession work, which we have been told to put a stop on at the moment. Mainly because financiers don't want to go down that track, don't want to go on TV. But the problem we're getting with a lot of people is that we're being asked to chase corporates that haven't provided directors' guarantees. And that's where a lot of the problem is at the moment, is that people that have owed money by companies without guarantees in their terms and conditions, we're out on a limb at the moment because we can't chase them personally.
Hang on a minute, John, if they haven't got a guarantee in place, then surely there would be some sort of, oh, well, we'll get to that later, but I'm surely there's some sort of legal law against that, and we'll get that to
Steve will answer that, but unfortunately there's not. There's not. And a lot of businesses can't get guarantees. A lot of companies now won't give guarantees. A lot of directors won't put guarantees up. So you're in a catch-22. So, but the market is, the market's in a bit of a flat space at the moment, and unfortunately, probably 3 in every 5 people I'm chasing at the moment have shut their doors. At the moment, so John,
would you say that you've gone from being really, really busy to not being busy?
I went quiet, but now we're getting busy again. However, people, I think they're clutching for straws at the moment because they're in a dire position themselves, and unfortunately, the debtors we're chasing, you can't get money from people that haven't got income, and there's a lot of businesses in that state, but not everyone's in the same position.
So how could they have avoided being in this position?
It comes back to good management and knowing your clients, but also having the right documentation in place, which is something I'll cover later on. But
sure.
And persistence, just having the processes right in the background, which is the important thing.
So if you're looking at the debt collection and what's going on out there, is it the same for every case? Like when you're collecting on one case versus another, is it different for one scenario to the other?
Yeah, it is. Because every debt is a bit different. Some are quite forthcoming and happy to try and assist. Others are just digging their heels in. There's a lot of disputes going on at the moment. You just try and do what you can. Each case is individual. We try and get a resolution. It may not always be 100%, but if we can get an arrangement in place or just a resolution, the main thing we find out when we're ringing people is there's some other stories behind why people aren't getting paid. And we seem to be able to find that out rather than what the client's getting told. So that's where we come in with that third party.
So if someone is now chasing payment, right? And we know that's pretty much like I'm seeing all over Facebook. What is the problem you're experiencing in your business right now? Cash flow. No one's paying your invoices. So if you've got some people on the call on this webinar today, what would you say that they should do if they've got invoices that they're chasing and they're not getting paid? What would you tell people joining us today to do?
People need to know who they're dealing with and really know what's happening in the background. The main thing is to know who you're dealing with and where their position is as well. We always recommend keeping up communication with your debtors. You know, knowing what they're doing, knowing what their position is, trying to retain that rapport. And, you know, if you're in the same position they are, you know where they're coming from. Believe it or not, we get a lot of business from the debtor that we're chasing because they're in the same boat. They can't pay someone because no one's paying them. So quite often we get a ripple down effect. But there's a lot of other options out. We say talk to people, bookkeepers. We've got one on board now, accountants, There's a lot of people out there to go out and talk to. And I often, through my history, have got connections to other people where we can put them on to someone else to talk to. There's options, there's some debtor finance, there's lots of different types of finance available that may get you through this period. And there's a lot of government grants and stuff that's available. So just, you need to get out and speak to the people that are really at the core. And your bookkeepers and accountants are the best people to speak to. They're the ones that are on top of everything.
Yeah, and Martin Kadak, who is our working capital specialist, said it very well in our very first webinar, which was that we ran in relation to finance. And he was basically saying that you should really just start talking to your suppliers and see if you can just extend those terms. Would that be something you like, just make a negotiation? Do you reckon that would work right now? I mean, we've got in 6 weeks. Is this all going to end in 6 weeks? What's going to happen? Is there going to be blood on the streets? What's going to happen?
Someone was going to say something then. The problem that we're facing in Victoria, we're not facing in other states. So I do a bit of work out of New South Wales and Queensland. So what I'm finding is debtors in the other states are trying to use Victoria's situation as an excuse for not paying. Yet we know that, like construction and that in New South Wales and Queensland haven't got the restrictions we've now got in Melbourne. But you know, it's just knowing where they are, who they are, and as you say, talk to them. If you can get an extension on your terms, you can provide an extension to the people you're dealing with. The main thing is to keep them on side, because once you get someone's back up, they'll be harder to try and get than what they are at the moment.
So answer the email and answer the phone.
Communication. We always say if you can't pay something and you need an extension, don't just think it's going to be given automatically. You need to speak. You need to speak to your financier, your supplier, even your debtor. Communication is the key. If you keep everyone on side, they're more inclined to want to work with you rather than against you.
I'm just going to pitch a scenario to you, John. So you've you've negotiated a payment, like extension, and then they break it. Would that be the time then they pick the phone up to you? Or, I mean, like if Martin has said in the past, go to your suppliers and renegotiate the terms, and then you find then that is still not paying, what would they do next? What would be the next step?
Well, unless you've spoken to the person, you need to keep in contact. And if that further arrangement's broken, then you need to look at why, and then you need to start looking at what further you need to do, because if it's getting worse for them, then you need to look at what options you've got available. So, you know, whether you're going to go maybe legal, what legal options are available to you, but you need to protect yourself and find out where they're at.
So what I'm hearing is that basically it's between now and September, just keep the communication open. But then when September hits, the end of September hits and all this stops, what happens then?
The magical question, unfortunately, and Steve will go into this, we don't know what's happening at the end of September as far as a lot of the restrictions on the collection side is going to happen. At the moment, that demands on amounts over 20 grand, 6 months. If they're not extended, it'll drop back to 21 days. So you could find a lot of people, if they've got the cash themselves, go that extra step now to try and protect themselves, depending on what the amounts are. So the market is expecting a flood of inquiries and people just not wanting to sit back and really find out where they're at.
And what I'm also hearing is that people are holding on to their money and they're not spending. So I suppose if that is the truth, then there would be a little bit of fat there to be able to start, repaying if that's what they're doing.
I think if people are holding their money back, they're holding their money back to try and survive through to Christmas. So you may not get paid, but at least if you're talking, you may be able to get drip fed something. So as I said, communication is the utmost key at the moment.
So going forward, what would you say that businesses really need to do now to start protecting themselves?
Well, if you look, as I said, with a lot of the cases we've got, between now and the end of September, now's the time for a lot of businesses to actually look at what their documentation and processes are. So they need to review their terms and conditions. They need to make sure there are cost clauses in them so that if they have to go to a third party, they have a clause in there that enables to claw back any costs like debt collection costs or commissions, legal fees. Make sure their processes are in place so that as they start moving forward and everyone comes out of this, that their process for collection and getting their debtors in is regimental. You know, don't allow someone 6 months. Get on top, keep records, you know, document emails. Just make sure that the process is all right, and that every time you speak to someone and they're laying back, you escalate the matter. Don't keep saying the same thing month after month. If you've got to get on top of your debtors, you need to escalate each time you go and do what you're going to say. You know, don't give them breathing space. And again, try and talk to them. If you can't get it all now, try and get a payment arrangement that will see something come through. But you know, just now's the time to sit down and make sure what process you have and implement a better system.
Okay, so you're saying to escalate, John. Then there's the relationship that people worry about. The relationship will be damaged if you escalate.
Well, if you've got a rapport with the client, with your client, you know how to speak to them. But if you've got someone that's not going to pay you, then you need to escalate it because they're just going to keep getting away with what they're doing. Don't say come back in 6 months and 6 months and 6 months and do nothing about it, because you won't get your money in. You need to be on top and you need to enforce. So, and there's plenty around to speak to.
Before I just hand you over, I'm going to put you on the spot here a bit. Before I hand you over to Stephen, if you've got a bit of a case study that you can share with us about something that has happened recently, that you just shake your head and go, oh, if they only just did this, they wouldn't be in this situation.
The best one I've got is a gentleman that was working with his brother-in-law, and it was an asbestos removal, and he hadn't been paid for 3.5 years. Now I'm chasing them at the moment, 300 grand.
Wow.
No, from a family member, and same thing. Documentation's very poor, no director's guarantees, and even though it's family, the process should have been in place. So all I can say to everyone out there, if you're dealing with your family, you know, family's family and business is business. So you need to make sure you're covered.
And I guess to the documentation, with the documentation, then that would be really needed if it went legal.
Not even just legal. If you've got a cost clause in your terms and conditions, you can use that as a deterrent to them and say to them, listen, according to my terms and conditions, I can on for the costs. So, you know, you can use it as a leverage to try and get paid or come to an arrangement, because you're making them aware that as this goes further, because you've got them in your terms, you can enforce and you can charge those costs onto them. So legal costs, commissions, debt collection costs, it's got to be in the terms. So as I said, we can't stress enough. Make sure your terms are right, and cover yourself going forward.
So over to you now, Stephen. What are the major differences you're seeing in terms of, from a legal perspective, in relation to pre-COVID and now in this COVID world, which seems like what I'm hearing, and I'm not liking what I'm hearing, is that it's never going to go away. In relation to your debtors and creditors, what are the major differences between pre-COVID and now?
Probably the main difference is people are playing the COVID card and just trying to put everything on hold. From my perspective, this was a very good period of time, a very good opportunity to get your debt and your creditors under control. The debtors that you have under control. And as John said, the best way to do that is by speaking to people. Now, a lot of people are simply saying, well, we don't have the ability to pay our accounts. that can be subjected to a critical evaluation by simply going out and having a look. I did that the other day. I drove past a debtor that said they couldn't pay. It's a retail outlet, and they had queues coming out the door because it was a food enterprise. So that's a practical thing you can do. And then from a legal perspective, and being a law firm, we act on behalf of both the debtors and the creditors. But from what you can do is if, and this is where it comes in to be relevant as to whether it's family members, whether they're valued clients who you don't want to annoy or alienate, but you can actually issue proceedings against them. And that will start accumulating cost, which they then have to deal with. And it'll also accumulate interest, even if you don't have an interest clause in your contract. And as John says, that's just so important to have a contractual obligation on the part of the person who owes the money to pay all the cost, pay all the interest, pay all the collection fees. But if it's not there, by issuing court proceedings, interest starts to run from the date that you issue. So that the other party might say, well, look, I can't pay at the moment, that's fine. But as long as I know in their own mind that the amount's increasing. It's increasing by way of legal costs and so on. And I think there's been a reluctance to take that step because of the uncertain times. And there has been a slowdown, definitely. But that's something that to bear in mind, that it is a good opportunity to start to remedy some of those problems if you don't have the contractual entitlement to claim interest and like. You issue proceedings and it starts to run, and then the person knows inevitably it will come to pass. But, not straight, deferred. I mean, the courts, we've had deferments of time in creditor statutory demands and all of those sort of things, but the courts, of course, are still acting to their own timetable. If you start a proceeding, there's so much time to put in a defence. If you don't do that, you can enter a judgment against them and you can have that judgment sitting there, which affects their credit viability. And you can take all sorts of steps in the course of a court case. The only thing you can't do is get a hearing date because everything's so stalled with courts being closed and the like. That's all being pushed off for quite a while.
I was going to ask you that because I was thinking, okay, so if someone here today goes, great, I'm going to issue proceedings and we'll get it heard in 2022.
Yeah. It's not quite that bad, but it's, there's certainly an element of that in it. Yes.
Yeah. And I'm just wondering too, is there any tips or tricks that people here today could take into account if they were entering an arrangement? Let's say they're doing what, say Mark and Kat was talking about, and John was saying, entering into a payment arrangement for an existing debt versus a new debt. What would you say that they should be doing?
There's a few aspects of that, but first of all, the advice I always give to a client is don't make an arrangement that you can't meet, because it sours the relationship to the point that you're not going to make a second one. Be realistic, do your best, and talk plainly with the other side about what is achievable and how it's going to work. You should always build in a caveat or two that things change. One day you might be open, next day things change and you're closed. So you've got to be fluid, but what John has said is absolutely right. It's this whole concept of communication. You're not going to trick people out of money or the like, but communication will allow you to at least find out what's available and you can put something in place.
What happens when changes that have been instituted because of this virus expire or lapse?
Well, yeah, there's a few aspects to that. Some companies, for example, might be thinking, well, we'll defer everything now, and when it comes crunch time, we'll just close the business down and start again. I don't know if everyone's familiar with the concept of phoenixing, but essentially that's where the proprietor of a business might own the assets personally and sets up a company to operate the business and leases the equipment and all of that type of thing to the company. so that if the company then goes belly up, the owner of the property or the assets can just take it back, set up a new company and lease it to the new company. Well, on the 17th of February this year, the government introduced anti-phoenixing laws. It's under the Treasury Amendment, I think it was, Illegal Phoenixing Act. So they're now trying to prevent that, and they're making directors personally liable. There's also the fact that in the new rules that are applying at the moment, there is certain forgiveness if a company keeps trading when it can't pay its bills. At law, if you continue to incur trade debt whilst you know the company can't pay its bills, that is what we call insolvent trading, and that's an offence. But that's been relaxed for the purposes of the current situation. However, it doesn't mean, there are certain rules that apply, and you need advice on this if you're doing it. There are certain rules that apply that won't protect you if you know you're not going to be able to pay the debt in the future, or you have any suspicions to that effect. Now, I'm not going to go into a chapter and verse, but you could have people coming out of this situation with all of this debt they've amassed because they've been able to, and it's not technically insolvent trading, but it may well then turn into insolvent trading if they are then not in a position to find their way out of that debt situation. So it could rebound. It could be quite, could have a huge impact on your business and on you personally, because in an insolvent trading situation, directors once again are personally liable.
Isn't that interesting you say personally liable, but then John was talking about directors not having directors' guarantees. So how does that fit in the legal sense?
Well, it's exactly that. When a director guarantees a contract, they're saying, you've got a contract with my company, and that's okay. You can sue the company if it defaults. But then you want a guarantee in place from the director saying, and if the company can't pay it, I'll pay it. Now, if you don't have that director's guarantee at law, you can't sue the director for the default of the company unless there is some particular statutory allowance for that, such as the insolvent trading provisions. And then the superannuation guarantee, if you don't put money away for superannuation for your employees, the government can have a go at you directly as a director. There are all sorts of provisions like that. But just to enforce payment under the contract, if you don't have a director's guarantee, you cannot have a go at the director unless you can prove there's been some sort of fraud or other inappropriate conduct.
So, Stephen, if someone was like here today and they were listening to this and they are owed money and they can't pay their bills, right now, do they need to go and speak to their solicitor, or what would it be? Or would it be, when they can really see that it's really going to be closer to bankruptcy because it's only 6 Mondays away, let's face it. Who should they be talking to? Is it their solicitor or is it John, someone like that?
I'll just briefly respond and then John can deal with it. But from our perspective, we see people on both sides of the coin. We see the people who are chasing money. We see the people who are being chased. And I think it is worthwhile speaking to somebody now in anticipation. As I said, the time we've had, this intervening time, has been a good opportunity to get your house in order, even though you might be incurring more debt or having a difficult time. There's been a lot of packages out there that have been of great assistance, and there still are now. I mean, the Commonwealth Government, I work with the Commonwealth Government, they're doing a lot of work to promote international trade and trade freight, and there's a lot of through export market development grants and changes to those rules and other assistance programs, people are able to get their products offshore still because the government's working to fund that. So sometimes it's just a matter of you don't know what you don't know, and if you go, it may be you say, well, you've got a debt, let's see if we can make an arrangement with the other side, or from the other perspective also, but or we can issue proceedings or whatever. and start to improve the position of the person either who has debt or is trying to collect debt. And in the person who has the debt, we might be able to stop the other side issuing proceedings by making arrangements, and therefore stop the amount that's owed increasing.
That's what I was just going to say, Stephen, like in terms of between now and 6 Mondays away, just knowing what your rights are, speaking to the people who can help you is so, so important, because I'm sure, I know, for example, in my situation, that my husband felt he could, fix it himself. And he told me when it was too late. And our marriage broke up, because then I lost all faith, thinking, why did you leave it so long? And this is when we have even more stress. So, I think it's so important that you talk to people like Stephen. John, do you have anything to add to that?
Again, between now and the end of September, I think it's important for people to go to their advisors, their bookkeepers, through the liquidators, as to what options are available. So if people have got concern at the moment, they do need to go out and speak to the people who specialise in those areas and see what's available, especially if they think they're down that path, because we don't know what's going to happen. We don't know what other laws are going to be passed or if things are going to be extended. So now's a good opportunity to speak to those in the know. And no one's better than your accountant who looks after your figures to know what position you're in. And they all accountants and bookkeepers do have connections to those other industries that can assist. So I'd use the time wisely.
Yeah. Well, I'd just like to open up to any questions you might have. There's no questions that I can see in the chat box. So if you have a question now, I ask that you put your hand up, because it's really important that you get your questions answered today. If you've got them, put your hand up, and then you can unmute yourself. Oh, yes, Damien, you can unmute yourself.
This is just a question for John. John, in relation to agreements and trying to put your new agreements in place now, are people signing agreements now, or are they just still holding off and not wanting to sign any agreements, not wanting to do anything whatsoever?
You're talking about existing clients or new clients?
Yes, typically existing clients.
Again, it comes back to that relationship. If you've got the rapport, depends on how good a client they are, as to whether you need to enforce something on. But I think with the market that's there now, I believe a lot of people would be prepared to have a look at what terms are, provided whoever's the debtor or the client feels safe in signing the new agreement with the new terms. But I'd definitely explore the situation at the moment to try and do it.
Okay, no worries. Thank you.
So, okay, well, I would like to thank you all very much for your time here today. And again, if you would like to reach out to John or to Stephen, all you need to do is contact me. You'll have my details from the emails that you've been getting from me. And I'd just like to thank you for your time. Thank you. Okay.
No worries.